In the previous session, we have seen the inclusive definition of person where we have seen list and that list starts with individual. So in this session, let us understand who is an individual and what is HUF. So who is an individual? The term individual means only the natural person, that is human being. So the term individual includes both male and female, and it also includes a minor or a person of unsound mind. So in case of minor or a person who is a lunatic, assessment will be done on the guardian or manager of such persons under section 161 subsection 1 of the Income Tax Act. In case of deceased person, the assessment would be made on legal representative. So this is something which we have to understand with respect to individual. Let's move on to Hindu Undivided Family, HUF. So in Income Tax Act, Hindu Undivided Family is treated as a separate entity for the purpose of assessment, because we understand assessment will be done on a person, and person definition available in section 2 subsection 31 includes Hindu Undivided Family. So for the purpose of Income Tax Act, HUF is a person and assessment have to be done on that person. Now, what is Hindu Undivided Family? Whether definition is available in Income Tax Act, answer is no. But the expression or definition is available in Hindu law, and this Hindu Undivided Family is basically a family which consists of all males lineally descended from a common ancestor, and it includes their wives and daughters. So I'll repeat again. Hindu Undivided Family is basically a family which consists of all males lineally descended from a common ancestor and include their wives and daughters. So the relationship of a Hindu Undivided Family does not arise from a contract, but it arises from a status. And there need not be more than one male member. I mean, there is no compulsion that you should have more than one male member. So there need not be more than one male member to form a Hindu Undivided Family. And the Income Tax Act also does not indicate that HUF as an assessable entity should contain at least two male members. So it is sufficient if there is only one male member available in HUF to be classified under person assessable entity. And in Hindu Undivided Family, some members are called as co-partners, meaning they are related to each other and to the head of the family. So HUF, the Hindu Undivided Family, may contain many members, but members within 4 degrees, including the head of the family, are called co-partners. So this is very important because HUF can contain many members, but the members within 4 degrees, including the head of the family, are called co-partners. A Hindu copartnery includes those persons who acquire an interest in joint family property by birth. Earlier, only male descendants were considered as co-partners, but with effect from 6th September 2005, daughters have also been accorded copartnery status. So it is to be noted that only the co-partners have right of partition in Hindu Undivided Family. And when we talk about Hindu Undivided Family, we should understand the role and importance of daughter. A daughter of a co-partner by birth shall become a co-partner in her own right in the same manner as the son. So being a co-partner, she can claim partition of assets of the family. The rights of a daughter in a co-partnery property are equal to that of a son, and this should be understood very clearly. However, other female members of the family, for example, wife, a daughter-in-law of a co-partner, or not eligible for such co-partnery rights. So the distinction here is the daughter of co-partner will become a co-partner, but other female members like wife or daughter-in-law of co-partner are not eligible for such co-partnery rights. And in Income Tax Act 1961, the Jain undivided families and Sikh undivided families were also assessed as Hindu undivided family. And when we talk about Hindu undivided family, we should also understand the schools of Hindu law. There are two schools of Hindu law. One is Mitakshara law. This Mitakshara law is followed by entire India except the West Bengal and Assam. Whereas the second law is Dayabaga school of Hindu law. This Dayabaga school of Hindu law prevails in West Bengal and Assam. So there is a basic difference between the two schools of thought with regard to succession. Under Mitakshara law, the inheritance is by birth. One acquires the right to family property by his birth and not by succession, irrespective of the fact that his elders are living. So every child born in family acquires a right or share in the family property under Mitakshara law. Let's see what Dayabaga law says. In Dayabaga law, nobody acquires the right share in the property by birth as long as head of the family is living. That is, it means children will not get any right or any share in the family property as long as his father is alive, and only on the death of the father the children will acquire right or share in the property. Thus, father and his brothers would be the co-partners of HUF under Dayabaga law. So we have to understand this. Mitakshara law is followed by entire India except West Bengal and Assam. So except West Bengal and Assam, entire India, when a child is born, automatically the child gets right for the property or right for the family property by birth. But in Dayabaga law, which prevails only in West Bengal and Assam, they don't get right to the property by birth, they get it only on the death of his father.